Families and the law. Parenting time and contact. Family law in Alberta is complicated, but learning about the law that applies to your situation is a good first step. This video is one in a series that talks about different parts of family law in Alberta. This video focuses on parenting and the law. If you are separated or divorced and have children, you need to figure out how to co-parent effectively. A parenting plan is an agreement about how to parent your child. It's an agreement about where the child will live, how to look after the child, and how to make decisions for the child. A parenting plan must be in the best interests of the child, not necessarily what you want. A good plan is easy to understand and is very clear about who is responsible for what. There are a lot of questions to answer in a parenting plan. Who will the children live with? What time will the children spend with each parent? Who will make decisions about the children? How will the parents make decisions together if both parents have decision-making responsibilities? What happens if one parent wants to move? What process will you follow if there is a disagreement? The process of answering these questions is the process of building a parenting plan, but you don't need to do it alone. A do-it-yourself agreement will save you time and money and gives you more control over the decisions you need to make, though it is a good idea to consult with a lawyer to make sure your plan is fair and enforceable by the court. You can work with a mediator, a neutral person who helps you work together to come up with an agreement that works for everyone. You can work with an arbitrator, a person the parties appoint to make a decision instead of a judge. The arbitrator will make a decision that is in the best interests of your children. Then there's mediation-arbitration, where a mediator is given the power to make a binding decision if you cannot reach an agreement. Lastly, there are collaborative processes, a type of negotiation where both parties have their own lawyers but work together to find a solution without going to court. If you can't come to an agreement, only then will you have to go to court. Going to court should always be a last resort. In court, a judge will come up with a parenting solution that is fair and in the best interests of the children. It's not about being right or wrong. It's not about punishing one parent while applauding the other. You will not be happy if this is your goal in going to court. In court, the judge will only think about the best interests of the children when making decisions about parenting. They will make sure any parenting plan, agreement, or court order protects the child's physical, emotional, and psychological safety and security. The person who starts the legal process decides which law and level of court to use. In Alberta, there are two laws, the Divorce Act and the Family Law Act. The Divorce Act applies across Canada and is only for married or divorced people. The Family Law Act applies only in Alberta. It's for married or unmarried people. These acts use different words to talk about people. The Divorce Act talks about spouses, people who are or who were married to each other. Spouses may be parents or step-parents to a child. The Family Law Act uses parent, which refers to a birth mother, biological father, or adoptive parents. And it uses guardian, a person who handles the care and well-being of a child. While typically a child's parents, the court can change a child's guardian. These acts also use different words to describe the responsibilities people have towards children. The Divorce Act uses decision-making responsibility, the ability to make significant decisions about a child's well-being. The Family Law Act uses the responsibilities of guardianship to talk about the roles of a guardian for a child. Both the Divorce Act and the Family Law Act use the same words to talk about the time people have with children. Parenting time is the time a parent has with and is responsible for a child. Contact is the time someone, like a grandparent who isn't a parent or guardian, has with the child. There are two courts in Alberta that deal with parenting issues. If you're responding to court documents, you file your response in the same level of court where the original document was filed. But if you're starting a new family law action, you have to choose which law and court to use. If you have not already filed for divorce in Canada, you file your documents at the Provincial Court or the Court of Queen's Bench to deal with parenting and contact issues covered in the Family Law Act. You can also use this process if you and the other parent were never married. If you have filed for divorce in Canada, you file your documents at the Court of Queen's Bench to deal with parenting issues under the Divorce Act. For more information on the process of going to court, see the Families and the Law video and booklet called Resolving Family Law Disputes. A few last thoughts about parenting and guardianship under the law. You can incorporate the views of your children into your agreement. A judge may also consider the views of the children, depending on their ages and maturity. Even if a judge asks a child for their opinion, their answer will not necessarily determine the outcome. The judge will make the ultimate decision based on what is in the child's best interests. If you don't agree with the judge's decision, you can appeal it, but only for certain reasons. You should talk to a lawyer before you take any steps. There are strict time limits on how long you have to appeal an order. Finally, you can change a parenting order or agreement. If both parents agree to the changes, then they can present the new arrangement to the court as a consent order. If the parents do not agree on the changes, then one parent can apply to the court to change or vary the parenting order. For more detailed information on this topic, visit cplea.ca/family.